Well, I might make a start then, because I think most people seem to have dialed in now. So I'd just like to start. My name's Ian Murray. I'm the chair of the Charity Law Association of Australia and New Zealand and an academic here at the University of Western Australia. And I just want to start by acknowledging that I'm based on the lands of the Whadjuk Noongar people here in Perth, and that the Whadjuk Noongar people remain the spiritual and cultural custodians of their lands and continue to practice their values, languages and beliefs. And I pay my respects to the elders past, present and future, and just invite each of you to reflect on the First Nations owners of the lands that you are dialing in from. Now, as you know, we are here really to celebrate Dr. Mary Synge and her wonderful book, which I'll hold at just the right spot so it doesn't get blurred for you. It's a virtual book launch and discussion, so I can't ask Mary to sign my copy of the book, which I'm a bit upset about. But the book is there available on Mary's website for those who are interested and would like to purchase a copy, and we'll send details afterwards so that you can, if you're interested, you can access that. But as you know, we're discussing this book on the university charity, Challenging Perceptions in Higher Education. And it does actually present quite a challenge to all those involved in academic or higher education to take a much closer look at the institutions that they work in or work with, and really consider whether the systems in place in those institutions are ensuring that universities behave in the way that charities might be expected to behave, or behave in other ways. And I should warn people that today's discussion is likely to raise confronting issues like, are you really working for a charity, or is your university actually something else? What does that mean for you? And also, you know, it might, taking on international students, large numbers of international students, is it really true that that's both advancing a university's educational purpose and research purpose if there's cross-subsidisation of research, or might it be detracting from one of those purposes to the benefit of another? Is there actually a balancing exercise taking place there? And I should also warn people that perhaps so challenging was Dr. Mary Synge's book that there's a note at the start of that book explaining why it has been self-published, and noting that the publishers were clearly so concerned about upset in the university sector that they had asked Mary to indemnify them for any complaint or allegation, whether true or not, and even if ill-founded, which sounds like an incredibly broad brush provision that would catch almost anything and any upset that anyone could possibly raise. So I'm hoping that has livened people up a bit for the discussion that's about to commence. So we will be getting into the meaty and interesting issues. In terms of a format, the plan is to have a panel discussion. Dr. Matthew Harding from the Dean of Melbourne University Law School is going to co-chair that with me, and we're going to talk with Dr. Mary Synge for about 25-30 minutes, and then open things up for questions after that. So just to introduce Mary and Matthew. So Dr. Mary Synge is a charity law consultant and author, and also an honorary senior research fellow at the University of Liverpool, and honorary senior fellow at the University of Melbourne, and a charity law scholar in the International Charity Law Network. A former solicitor at Linklaters, she was awarded a PhD by University of Bristol, and has held academic posts at Bristol, Cardiff, Exeter and Reading. We're obviously talking about her second monograph, but her first monograph, The New Public Benefit Requirement, Making Sense of Charity Law, was published in 2015 by Hart Publishing. And to introduce Matthew, so Professor Matthew Harding is Dean of the Melbourne Law School, one of the world's leading academic experts on the theoretical underpinnings of private law and the law of charities and other not-for-profit organisations, and his work combines theoretical, doctrinal and practical insights, and he's published extensively on topics in the theory and doctrines of equity, charity, not-for-profit law and regulation, the law of property, judicial practice and precedent, and the philosophy of trust and trustworthiness, and he's now ensconced in the administration of universities, possibly charities, so he's well placed to talk with us today. So Matthew and Mary, let's open proceedings. And Matthew, I think you had the first question that you wanted to pose to Mary.
Thanks, Ian, and it's a real pleasure to be here and to be celebrating this book and this wonderful scholar who's written it. Well, Mary, you and I have been talking for a long time about the ideas that ended up in this book, and it's been quite a journey. So I think we should start by hearing from you what motivated you to write this book. What was driving it?
Well, a very early motivation, frankly, was the look of bafflement on my students' faces when we talked about universities being charities. It was quite clear they didn't see their university as a charity at all. And I think, in common with most people, probably thought of it as a public sector body or large business, if they'd thought about it at all. So I wanted to address that. Another motivating force was the huge encouragement I received from you and others. I mean, you and Una, hello Una, may remember breakfast that we had at a conference in Wellington in 2018. And over breakfast, I mentioned this idea, which was rapidly becoming a bit of a book idea. And apparently this book had to be written. And apparently, and slightly more questionably perhaps, I was the person to write it. But you were really encouraging from then and after, and many people have been since. So I received a lot of motivation in that encouragement. But obviously I needed a huge amount of self-motivation as well. As some of you will know, I wrote this book largely at a time when I was unemployed and unpaid, voluntarily, I hasten to add. So I needed self-motivation, but that was easy to find in the questions I was asking. These were really important questions that I wanted to ask based on my interest in and concern for both charity law and universities. So on the legal side of things, I had come to realize, I think, that charity law is little understood. It's prone to being distorted for political ends, I believe. That was the subject of my first book. And could I do anything to help overcome that? And there also seemed to be a question about coherence in law. So if universities are charities, they should be treated as charities like any other. And of course, on the practical side of things, applying that law, that was all the motivation I needed. I don't believe I'm the only one who's disillusioned about our universities. And so if charity law could possibly provide a way forward that might bring about improvement in our universities, frankly, that was all the motivation I needed. I mean, speaking as a grandmother now, for goodness sake, I care passionately about our universities, and I do believe that charity law provides a legal and coherent basis for looking at universities differently and possibly bringing about some sort of improvement. So that motivation was my primary motivation, I think, and it kept me going almost at all points. I would have loved you to have written the book instead, but you kept refusing, so.
It was written by the right person.
And Mary, linked, I guess, to that idea of really trying to bring about an improvement in universities, I guess my question for you is, setting out things up front for everyone listening, what's your key message for universities? And I guess when we're using the term universities there, that's a label that then covers a whole range of different stakeholders, whether that be senior management, academics, students, but what are the key takeaways that you want the people involved in universities to have?
Well, there are many takeaways, as you know, and there are many messages in the book. There are many tentative conclusions, and there are many invitations. This is very much a launch pad, this book, I hope, for future research and for debate. I really welcome this opportunity to start that debate as well. If I had to pick out one key message for the universities, and as you say, all the stakeholders in the universities, I have to say it would also be the key message for government policymakers, regulators too, and that is, could we take charity law seriously? You won't be surprised to know that it was Matthew, actually, in one of our many Zoom meetings, who once, I don't know what I'd been talking about, probably wittering on for some time, and he said, really at its heart, this book is a plea to take charity law seriously. And I hadn't thought of it in those terms, but he was absolutely right. It is a plea to take charity law seriously. And that applies to all the various stakeholders. And I say that it has to be taken seriously. What do I mean? Well, charity law has to be understood. And yes, there are some areas that require clarification. They might require refinement, but it also has to be respected and it has to be applied. That way, I think we gain coherence in the law, which was one of the questions I wanted to ask. I also think we gain one possible way of achieving improvement in our universities. But it's more than that, I think, for the charity sector generally. As I wrote the book, it was only during the passage of writing the book that I came to realize just how much we do need to take it seriously, that the dangers the charity sector is facing, not just from worrying behaviours internally, maybe poor governance, either deliberately or through lack of understanding, weak enforcement mechanisms, poor accountability mechanisms. We always face those problems, but also the risks from intrusion and interference from the state, or co-optation by the state, as Catherine Chan calls it. We face those dangers. We also face the risk of takeover, frankly, by business, I think. And if we recognise those risks, and if we want to do something about it, it just seems to me that charity law provides the way. I'm not talking about new charity law, I'm talking about long established charity law. And I just think there are many ways in which, if we understand that law better, we respect it and we apply it and we enforce it and we educate people about it, that seems to me to be really, really important. And that's what I try to summarise in chapter 11. I appreciate it may sound a little bit dramatic. I seriously don't think it is. So that's my key message. Let's, understand charity law, respect it and apply it.
Thanks,
So
Mary.
Mary,
Sorry, Matthew.
no, it's okay. So Mary, there's quite a lot in the book that relates to university governance and management, and you cover topics, that sort of suggest in places that universities might need to be very mindful about questions of mission drift. You talk about executive remuneration in universities, which of course has been a very big issue at times in the UK and in the US, arguably less so in this country, but it does pop up from time to time. Do you want to elaborate on some of that material? I mean, what are the key arguments that you're wanting to make in the book around these questions of governance and management?
In the context of remuneration?
Well, you could take that as an example, but more broadly too.
Yes, okay. Well, links with mission drift and governance for sure. And as you say, remuneration is one of the big issues. It tends to attract the attention and the excitement of people. I'm not sure it's the most important, but it's certainly a key one, and it does allow us to think more widely as well. There's a reason it was the longest chapter. Clearly, with this charity law lens I was bringing to universities, I wanted to ask what charity law had to say about remuneration. And it seemed to me it has a great deal to say. There's also very little guidance, certainly in our jurisdiction, from the Charity Commission about remuneration. Our commission appears to me to be quite reluctant to get involved in issues of remuneration. Sector regulation and guidance barely mentions charity, so often doesn't mention it at all, actually, or possibly sometimes gets it a little bit wrong when it tries. And ineffective regulation. So there was a reason it turned out to be the long chapter. But in terms of links with mission drift and governance, well, taking mission drift first, I suppose our first question should be, is there mission drift? And that's a question I try to ask in chapter 4 and open up some discussion around. But it seems to me there may be. So to the extent that universities might be seen to be pursuing, I know it sounds simplistic, but power and prestige, or the sorts of metrics which feed ambition in university rankings, maximization of student numbers and growth and so on. I think we may be seeing mission drift, and these are arguably goals which conflict with or even undermine the charitable purposes. And to the extent that remuneration levels tend to be justified in those terms or explained in those terms, then yes, I think we do see a link with mission drift, and the charitable purpose has to be brought to the fore. And of course, all those decisions come down to internal governance. They're not imposed from outside. So the question of how the governance structures and practices are designed and followed through on it is key. There was a report in the UK not long ago that 95% of our vice-chancellors were either sitting on or attending remuneration committees. And in fact, that was permitted by the sector guidance at the time. That seems to me not very heartening from a charity law perspective, or indeed from any other perspective. But there are also questions about conflict of interest in perhaps less visible ways or less obvious ways. So taking bonuses, for example, not all universities pay bonuses, but a good number do, and they can be quite high. So the question I'm asking is, to what extent are the executives who receive those bonuses involved in or influencing the sort of objectives which are designed in those bonus schemes against which performance is measured and by which the amount of bonuses is calculated. So things like that. So it does seem to me that, yeah, looking more broadly, universities in terms of mission and governance may have mutated towards a business model. That's one thing to adopt the terminology and the pay packets of big business. But if at the same time you don't also have the reporting obligations of big business, you don't have the shareholders who can bring derivative actions or remove members of the governing body or have binding or non-binding votes on remuneration policies, then that's a bit of a problem. So that's a bit of a summary.
Yeah, thanks, Mary.
Your question, Matthew.
Thank you. I think, well, we might come back, or I think Ian might bring you back to governance in a few minutes' time. So some of those thoughts that you put out there, we can explore a little further in a minute. I wonder whether it might be useful to take you in a slightly different direction for a few minutes. You've written a book about universities, and in many ways, universities are very distinctive organisations, and that comes through very strongly in the book. They're charities. Well, we assume for the sake of argument that they're charities, but they are distinctive. Insofar as they're charities, they are nonetheless distinctive. But I think there are clearly lessons from your analysis of the universities that can be applied to charities more generally. And so I wonder whether you could say something about what you think are the key lessons that apply for charities generally based on your study of university charities.
Well, I have to say, I'm glad you're asking the question, and I'm particularly glad that people have now read the book. This is one of the things they're saying, that actually this speaks to the charity sector generally, which, of course, I hoped it would, but I realised the title might have been a bit narrowing then. The whole thing speaks to charities generally, I hope. The very first question, of course, I had to ask was, well, are our universities actually charities at all? Which requires me to look at the law of charitable status and actually to address some pretty grey areas, whether gift or benefaction is required, how severe is the exclusively charitable purpose rule, what difference do provisions about dissolution make, and so on. And those grey areas are particularly where the state is involved. So when can the state establish a charity? How much independence is required between charity and government, and so on. So I think all that area applies to charities generally. I mean, when you say whether our universities are charities, I actually changed my mind about some of our universities during the course of writing the book. The universities which we now call the post-1992s, which were polytechnics and very firmly in the public sector in the 60s and 70s and early 80s, I think I've reached the conclusion that those weren't effectively transferred to the charity sector by the reforms of 1988 and 1992, which removed them from local authority control, changed their governance slightly, and called them universities. But all that law around charitable status, I think, speaks to all charities, as indeed do all the other charity law frameworks. So in respect of each of the subjects, whether it's governance or remuneration or sales and conversions of charities to for-profits and so on, I try to set out a charity law framework. Excuse me, I'm sorry. Just emerging from flu. I was hoping this wasn't going to happen. And I think all of those refer to all charities. Some passages are going to apply to some charities more than others, of course. You know, a discussion of regulation of exempt charities won't be relevant to some. Public benefit I tend to restrict to fee charging charities. And I hope also to other jurisdictions, particularly Australia and others, New Zealand, which share our heritage in charity law. Of course, there are some differences. And again, there'll be some English eccentricities, if you like, so you may glaze over when I discuss sections 105 and 106, although the underlying principles might still be the same, and exempt charities, I think, remain unique to our jurisdiction. But as for the relationship between the charity and the state, which I think is one of the key themes of the book, and I think that one speaks really loudly to all charities. It seems to me, and you've written about this before, I know, the dividing line between charity and government. Where is that line to be drawn? But how important it is to draw that line. for us to understand where it is to be drawn, what it means to say that charities should be independent of the state, the nature of the duty on the trustees to retain that independence, what it requires from the state to respect and uphold that independence. And it seems to me there's been some scholarship around moves from grants to contracts and the conditions attached to funding and so on, and the threats to that line. And I think that's one of the key themes in the book. And again, I say that charity law gives us the means to understand that a line has to be drawn, where it has to be drawn, and to resist moves which seek either to cross that line or indeed to redraw it elsewhere. So I do think that's one of the key messages for all charities. But yes, I do think that, well, I hope that all the charity law frameworks there will be useful more broadly.
Thanks, Mary. Okay, so you've just pointed to the very important distinction between charities and the state. Another important distinction that I think emerges from the book very, very quickly is the distinction between not-for-profit and for-profit. And I wonder whether you could reflect a little on what you say in the book about circumstances in which universities engage in profit-seeking activity, or cases where, and you refer to some of them in the book, where assets dedicated to charitable purposes are sort of reoriented and end up in profit-making structures. Would you like to say something more about what you've put forward in the book on that topic?
Yeah, I think you're getting at chapter 10 here, I think, are you? The for-profit, yeah. In chapter 10, I addressed two transactions which have taken place here in the last decade, or last 11 years now, involving the College of Law and Regent's University. These were both registered charities, and both sold their assets and undertakings to private equity, which now run the universities now on a for-profit basis. The original charity, either at the time or in one case 10 years later, changing its purposes, becoming grant-making charities, at least initially, sometimes giving grants to the students at the for-profit universities. I have to say, yeah, thank you. Apart from the state and government thing, this is another key theme, and it's another threat, I think, to the charity sector. And chapter 10, I have to say, was probably the most difficult chapter to write. It was never in my original plan, but it became obvious I had to include it. It was the most difficult for two reasons. One, the lack of information publicly available. Our Charity Commission explained that it had decided to make no information publicly available. Replies to my freedom of information requests were extremely limited. Information normally withdrawn on the law enforcement exemption under the Freedom of Information Act. It was also difficult because I had discussed these transactions on a number of occasions with quite a large number of charity lawyers. And I hope I don't misrepresent anyone, but I got the impression that we all felt distinctly uncomfortable about these transactions, but somehow couldn't quite put our finger on why we felt like that. So I felt it imperative to include this in the book, and it rapidly became a chapter. Why did we feel uncomfortable? Well, I think the dangers inherent in these sorts of transactions where a charity becomes a for-profit or it sells everything to private equity are quite clear, and they're clear in the scholarship around conversions of not-for-profit hospitals to for-profit hospitals in the United States a couple of decades ago, where several states, quite a number of states actually, introduced legislation to govern these transactions. And those dangers are around valuation. How do we value the land that's been held in a charity for possibly hundreds of years? It's not regularly on the market, for example. How is the consideration structured? Is it all paid up front, or is there any part of the consideration which is deferred and contingent upon the performance of the for-profit buyer, for example? There are questions around governance. Is the governing body making this decision with sufficient time and sufficient advice, or is there any influence coming from the executives or the buyer, or indeed the government? I mean, in the College of Law's case, the minister involved has written a book, and in it he talks about this transaction where the relevant government department worked tirelessly, it seems, to facilitate this deal. And I think if the government had been involved to that extent in maybe the sale of a large cancer charity and its premises to a private equity buyer, I think we'd have all been raising eyebrows a great deal more. So there are lots of questions, obvious potential conflicts of interest, both among advisors and among executives who go from the not-for-profit to the for-profit and so on. And it seems to me in the legal framework that I set out, the legal framework acknowledges those dangers and provides safeguards. But were these followed in this case? I don't know. I'm certainly not suggesting anyone's behaved unlawfully, but it would help, I think, if we all understood these transactions better. Spoiler alert, it just seemed to me, why was this not a scheme? The Royal Holloway College required a scheme in order to sell 3 paintings. Why did the College of Law not require a scheme in order to sell a property portfolio of £200 million and change its purposes 10 years later to becoming a grant-making charity? So I just think there are some really urgent questions that require clarification. In my view, yes, it was a scheme that was needed, and actually a scheme by the court because of the restrictions on the Commission's scheme-making jurisdiction set out in our Act. So I really hope this is one area where our Charity Commission might engage, might read this book and provide some explanation, some reassurance, and that we might all understand, because there is evidently confusion even in the legal advising sector as to what should happen here. We see a for-profit duty quoted in the reports, for example. We see policy papers talking about stripping profits from the charity. And I think, yeah, thank you, Matthew. I think this is one of the important areas.
Thanks, Mary. I might hand over to Ian.
Thanks, Matthew. And so, Mary, I want to bring you back to the area of governance. You sort of teased us a bit earlier with some initial thoughts on governance, but it would be good to sort of delve into that a little bit deeper now and sort of explore what that might mean both in a university setting and beyond. And I think one of the really interesting discussions in your book is about governance models within universities and the way some universities, and maybe you can talk us through this a bit, but like Oxford and Cambridge intimately involve academics in that governance process. Other universities are moving more to a corporate model where academics are less involved in that overview of university operations. I mean, some might say we haven't moved far enough to a corporate model. You know, we don't have a small board that can actually control the executive. Maybe that would not be such a bad thing to happen. Maybe executives are off doing their own thing without much oversight. But I won't get you to speculate on that. I would like you to talk us through a bit this idea of involving academics more than perhaps they are always in the governance processes of a university. You know, how might we achieve that? How do you convince time poor academics that they should turn up to meetings? Yeah, can you just talk us through that idea a bit?
Yeah, it's interesting, isn't it? I do make the point in the book, I don't think governance models in 2 universities are ever the same, but I do describe a spectrum, as you say, with Oxford and Cambridge at one end and the corporate model at the other. But I rely heavily on research that's been undertaken by Michael Shattuck and Nico Horvath in describing that process. Yeah, and Australian universities, I suspect, are very different. But the call for academic participation in governance is actually voiced by many commentators in the university literature. So it's not just me calling for that, I think many people are, but it's interesting that it's completely supported, in my view, by a charity law analysis. And I base that on the fairly simple premise, I think, that academics, in my view, are less likely to pursue the power and prestige or the metrics-driven practices that I spoke of earlier. They're less likely to endorse the remuneration decisions and so on. It's the academics who, on the coalface, if you like, are advancing education and research for the public benefit. So you might even think it's self-evident, but certainly desirable that they are involved. As for how you do it, well, this is one of the debates I hope that this book will open up. And as you say, not just for universities, but this question of purpose-based governance, where structures and practices are centered around the charitable purpose, is key. I suppose in universities, you might begin by reversing some of the changes that have occurred in the last couple of decades. So you might restore more academics to governing bodies. You might restore more academics to Senate, or at least change the balance between academics and executives. It depends what's happened, obviously, but restore more authority to the Senate as well. Maybe elect more members, heads of faculty and so on from within the institution with academic voice rather than external appointments by the executive. I think there are many ways you could try and restore the council Senate axis of authority rather than the council executive axis of authority, which many have adopted. But however you do it, that has to be genuine, doesn't it? Has to be genuine and practicable. So I think there's very limited benefit in extending consultations in which academics can take part, or opening up more working parties and so on. And this is because it's a matter of trust. And I think in many places that trust is broken. And if, as you mentioned, time poor academics, I think, let's ask why they're time poor. To some extent, that's because the activities they undertake all the time are not recognised by workload models. So if we're going to bring academics back into governance, that time has to be recognised and respected. The model has to work. Again, it's a trust issue. Now, I think this is a debate to be had. Governance is not rigidly set out in charity law, but that guiding principle of putting the purpose at the centre of everything, I think, provides a legal and coherent basis for doing it. You could change governance in many, many ways. It doesn't have to be done in the name of charity, but I do think it provides a very good framework.
Well, I'm looking forward to that debate ensuing about involving academics more so in governance. I think it's a good one, and one that we need to have here in Australia as well. So I don't think that's unique to the UK. But maybe I can bring you back then to one of the key ideas in your book that you really emphasise is just, if you adopt a charity law lens, that means that we think a little bit differently about the duty to act in the best interests of the entity, being the university in this case. And from a charity law perspective, what that means is a duty to act in the interests, maybe the best interests of the charitable purpose, not the entity. That then has a number of ramifications. I was sort of interested in I guess, two aspects of that. One is, relating to how you ensure that happens. And we've talked a bit about involving academics throughout the coalface. That might be a process related way of achieving that. Another way, which you haven't explored in detail in your book, so you might not have sort of thought this through to a large extent, but might be, a transparency type requirement. We ask university governing bodies to publicly justify decisions they make by reference to their charitable purposes of advancing education and advancing research. I was interested in your thoughts on that, given UK experience with public justification for the public benefit reporting that's required. And then I've got another question, but I might stop there and let you comment on that before I had sort of another question related to that best interest duty. But yeah, what are your thoughts on whether public justification would actually work or not?
I think it's a great idea. It's a good guiding principle, isn't it? If we're saying that's the basis on which decisions need to be made, then asking for an explanation of how they've been made on that basis seems to me very reasonable. I suspect in the interest of practicality, it wouldn't be all decisions, but maybe key decisions. And actually, I think I do suggest it in the book in relation to remuneration decisions. And the National Council of Voluntary Organisations, the NCVO here, in its report on remuneration, suggests exactly the same for all larger charities. And I do think that would seriously challenge present justifications. If you read a university's report, and of course they all vary, but if you read a typical report, if you were to see instead, these remuneration decisions are in the best interest of the charity, because I think that would present a very serious challenge to those present justifications. I believe myself that it'd be quite effective in restraining pay levels. It might even also prevent certain types of pay. So if I give you one example, I give the example in chapter 5 of a vice chancellor who's paid more than £100,000. If he did not offer his services to any other university for 12 months following his retirement. Now, I know I've talked about this before, but how do you justify that as being in the best interest of the charity? I do attempt in chapter 5 to see it in the round and consider the alternative view, but I, for one, am not persuaded that that's in the best interest of the charity at all. That seems to me to be paying someone distinctly not to pursue the charitable purpose. So it might make a difference there. But yeah, as a general principle, grand. And reporting on that basis would, I think, at least it would focus the members of the governing body's minds that that is their duty and that is what they're there to do. So even if it's not provided in a public explanation every time, I think it would be a very good reminder and endorsement.
Well, that's a great segue into the other question that I had, which is, if we really take seriously this idea, the charity law perspective of acting in the interests of the organisational purpose, the charitable purpose, rather than the organisation as a separate entity. I mean, I think that's implicated in your discomfort about remuneration that stops you pursuing that charitable purpose for another entity. How could that possibly be justified in the interests of a charitable purpose? But from a broader perspective, what does that have to say about thinking about cooperative rather than competitive behaviour in the sector, and maybe even the way we think about ranking? Are we ranking individual universities? Should we be ranking successful cooperative behaviour that actually best achieves the charitable purpose? Anyway, just interested in your thoughts on might we see more cooperation if we really took that purpose focus seriously?
Well, I think we would, and again, this is one of the debates that I hope the book is going to open up. But you're right, charity sector is all about collaboration. The university sector tends to be, well, the messaging is about competition, less so perhaps when it comes to setting fees or facing the unions and their demands for pay, where the fact that some in the sector might not be able to pay it seems to come to the fore. But otherwise, there is quite a divide, isn't there? What difference would it make in terms of university practices? Well, we academics are used to collaborating. It's what we do. We will, informally review a colleague from another university, their grant application or draft publication or something. So maybe we see greater support for recognition of that sort of practice. And yes, you're right. Maybe we start seeing that as success. Whether it feeds into rankings, I don't know. As interesting here, our government has said we don't think rankings is a suitable way forward for charities. It seems not to apply in the case of universities. But we might see that. What about teaching? Maybe greater collaboration in teaching. And I have to say, charity law seems to be a prime candidate. One of my great concerns is that, at least in this jurisdiction, we don't seem to teach charity law. And if you are in that corporate model end, teaching charity law, where there might be an initial take-up of, say, 30 or 40 students, it's not the most sexy of subjects, if I can say that. It's, in terms of resource efficiency, it's not very appealing. You might have only one member of staff who can teach it, not enough students in the classroom and so on. And it becomes very difficult. But if you had a more collaborative approach, surely we can find a way of teaching charity law if we think it's important enough across universities. So that's one idea. In terms of regulation, would we see any difference? Well, first and foremost, I'd like to see in the regulatory framework and in guidance greater emphasis on collaboration over competition. That would make a big difference, I think. We might see, competition-based practices regulated, such as the non-competition clause, where I understand many in the sector had thought a regulator would act in that instance, so I've since been told. And then importantly, of course, I think we might see a very different regulatory approach to conversions or sales to for-profits. We might instead expect to see collaboration with or transfer of assets to another charity, for example, rather than the encouragement and the facilitation of transactions to for-profits. So those are some differences maybe we'd see. I'm sure there'll be many others. It's an interesting question.
Thank you, Mary. And we have a bit of time now really to open things up for questions that those who've dialed in might like to ask Mary. So I'll stop talking there and just ask, if you'd like to ask a question, please just raise your hand. or somehow otherwise indicate to me that you would like to do so. Murray Baird, I can see that you're first on the list.
Thanks very much, Mary. You mentioned regulators in your reference to transactions to the for-profit sector. How do you think regulators such as the Charities Commission will read your book and be moved by it? And or are universities just too big to fail the charities test and therefore hands off?
Well, I do hope the Charities Commission will read the book. How it will be moved by it, I don't know. But I think the call there on the regulatory approach to the for-profits is around this idea. Even in light of the Charities Commission guidance, I would have read that and expected a scheme. And yet the Commission consented to the sales on the grounds of expediency and treated the change of purposes entirely separately. So I think there are a lot of areas there where the Charities Commission, I hope, will respond and provide greater explanation, if not with specific details to these transactions, then more clarification over its practice compared to its guidance. I don't know whether that answers your question.
Well, so as a follow-up, do you think the Commission would ever challenge the charitable status of a university?
Well, that's an interesting one. I think we could all challenge the charitable status of a university. I don't think the Charity Commission would. I don't know, it'd be very interesting. I'd be interested to know what the Charity Commission, how it would respond to my suggestion that the post-92s aren't, and the reasons they might not be, on the exclusively charitable purposes rule, the lack of independence and the lack of clarity over when they're established and so on. I don't see them challenging it, partly because they are very clearly called charities. I don't know on which grounds they might challenge it. They might follow my challenge to those post-92s, I don't know. I don't see them doing it. I see that the Charity Commission, my sense is that it probably doesn't want to get involved in universities. They're large, complex institutions. There would be a great deal there to look at. And I think also, I have to say, the relationship between universities and government and between Charity Commission and government, my sense is that there'd be a dynamic there that might make them want to be hands-off universities. But our Charities Act in 2006, it ended the historic exemption from regulation which applied to universities. And it was recognised in the passage of that act that universities, yes, they were regulated, and some would say heavily regulated, some would say too heavily regulated, but they weren't being regulated as charities. And the reforms in the 2006 Act was intended, it was said, to put universities on a level playing field with other charities and to regulate them as charities. Now, they could have brought the universities across to the Charity Commission, but they didn't. So we had this new regime of principal regulators who would be responsible for promoting compliance with charity law among the exempt universities, which is most English universities. So they're still called exempt charities, unfortunately. And the principal regulator for most English universities is the Office for Students. But are we seeing the Office for Students regulating universities as charities? No, I don't think so. Should the Charity Commission be concerned about that and acting more with the OFS? Possibly. There are all sorts of questions there over the regulatory framework, but I certainly don't think that the reforms of 2006, what we understood to be the goal, has been achieved at all. If anything, it's been further undermined. But we, of course, have some universities that are registered with the Commission. But I just don't see the Commission wanting to be involved at all.
Thanks, Mary.
I've got a short follow-up question then to Murray's one. In a lot of jurisdictions, the group of entities that get upset about universities being charities are local governments because they miss out on rates. So in the US, there's sort of a long history now of universities voluntarily paying, a reduced amount of local government rates because otherwise local governments would miss out. Is there any, is that a phenomenon in the UK? And is there any chance that local governments are going to pick up your book and decide that they'll be the ones to champion this idea that many of these exempt rating entities are perhaps not and should have been paying rates over a number of years?
Well, that's an interesting question. We'll have to see. I don't know whether local authorities are going to be picking up the book, but it's certainly something I raise in the book, that I think, in a way, raising the profile of the charitable status of universities, I suspect that's one of the first questions that's going to start to be asked. And yes, looking at the moves in America, and I know there are some moves taxing in Australia as well, the business rates relief is key. And yes, I think we might start to see that talked about. I think I quote someone, a councillor in Bristol here, who challenged Bristol University for its rates relief from saying, come on, this isn't on. So maybe those movements among the public are going to happen, like they've happened in the US. In Scotland, interestingly, there was a review into business rates relief and whether it should be removed from universities and independent schools. And actually that review concluded that no, universities could keep their reliefs, but the reliefs for independent schools have actually been removed in Scotland. In Wales, a similar consultation was carried out, but didn't mention universities at all. And we, as to my knowledge, we haven't yet seen one in England, but that might be the next step. So yes, I do think that, yeah, the challenge to the business rates relief is probably going to be picked up at some point, I would imagine.
Thank you. Do others have questions that they'd like to pose for Mary? They've been wowed by your presentation, Mary.
Well, they've all fallen asleep.
Oh, Michael, do you have a question? Oh, you're on mute, I think. Hang on.
You're right, I'm off mute now. Thank you. Thanks, Mary. Yeah, I just had a follow-up question really to Murray's and Ian's question on the regulation side of it. And I was interested just what learnings we might take in Australia from the regulatory amendments in the UK in 2006. I've just had a look at the Universities Australia page here, what it says about regulation and accreditation of universities in Australia. And it talks about how Australian universities operate under a framework of government laws and regulation. But noticeably absent from that discussion is anything to do with Charities Law or ACNC. It talks about Higher Education Support Act and Tertiary Education Quality and Standards Agency, etc. So we have, as far as at least Universities Australia is concerned, we haven't got the stage of even contemplating the ACNC as a regulator of universities. If we were to have a debate about principal regulators or regulatory structures, what kind of things would you suggest should be at the foremost of our discussion to go down a regulatory structure which makes sense for charities, as against one that, as you're suggesting, the UK hasn't quite worked?
Well, I think in Australia, aren't all universities registered as charities?
Oh yeah, absolutely, yeah, and they're listed in the Income Tax Assessment Act, so it's an automatic registration.
Yeah.
So
one would expect to see the ACNC regulating them perhaps as charities.
One would, but I guess I was just struck by the fact that the Universities Australia page, which is presumably a reasonably significant organisation in terms of understanding the regulatory structure of universities, makes no mention of the ACNC. It just doesn't appear to be sort of as part of their contemplation. So, which suggests to me that we actually need a debate about regulators that you seem to have had back in 2006. We're not even at that stage, I think. I think it possibly means we need to be active about that.
And Mary, perhaps I was just going to expand on Michael's question to flag. I think at a previous ACNC Regulators Day, if I recall correctly, the then Commissioner indicated that the ACNC didn't have an interest in regulating universities because there was an assumption that they were already heavily regulated. And so it'd be a very odd step for the ACNC to actually take action. So I guess it would be particularly interesting for your perspective on when you can convince a charities regulator to actually step in and do something, the challenges that you've experienced with that, how did those 2006 changes, to what extent did that actually cause not just a change on paper of universities being regulated by the commission, but how was the commission actually convinced, or is it being convinced to step in and actually do anything about, from a charity perspective, universities?
From my knowledge, I don't think there's much difference between our two, actually. We had a lot of talk about it in 2006, but I don't think the talk we had about it or the reforms that were brought in have made any difference. But that assumption that you say that, yes, I remember asking a member of the ACNC when I was in Melbourne whether they were interested in universities, and the distinct impression I got was no, they wouldn't touch the universities. But I think we have to question that. If there is that assumption that they're being regulated as charities, there was more than an assumption in England and Wales when the Charities Act 2006 went through. There was an agreed understanding that they were not being regulated as charities, and there was a wish to say, right, we must regulate them as charities. We need consistency, a level playing field in the charity sector. There was obviously concern that they weren't being, there had been some understanding, oh, well, universities are full of lawyers and accountants, they don't need regulating as charities. Well, I think we can all push that to one side. But as to whether it's made any difference at all, I don't see that it has. And I think it's this reticence of the regulator to be involved. Do we mind? I suppose what you do is you look at regulation of the charity sector and see what's missing in regulation of the university sector in the name of charity. And we could probably all come up with some ideas there. But ultimately, of course, it comes down to regulation of the charity sector. How effective is that? If we had a really good regulatory framework and approach and practice in respect of charities generally, it might be somewhat easier to pick that across and apply it to universities. But I think the whole question of regulation of charities is a difficult one. It's multifaceted. Commissions or ACNC have limited resources, huge number of charities, etc. But so between our two jurisdictions, I don't actually think there's that much difference. We may have had more discussion, but I don't think we've achieved anything more. I think the regime for exempt charities and principal regulators is fundamentally flawed. And in Chapter 9, I pursue that a little bit more. And of course, we've got registered universities, we've got exempt universities. So I look at the regulatory framework. It shows the very different regimes that apply on paper, but in practice, I'm not sure that any regime is applied particularly. Having said that, the Charity Commission has got involved recently in the Christchurch Oxford, where there was a huge governance issue, which you may have read about in the press. And the Charity Commission, my sense again was it was slightly reluctant to get involved, but it did get involved, and it ended up issuing an official warning, largely to do with the costs that the college was spending on legal fees and so on. So the Commission has become involved there. Maybe that will be the start of something more. Maybe it will read my book and respond. I don't know. But it's a really interesting question. I'm sorry I haven't got a better answer.
Thank you, Mary. And I can see that Jennifer Petruni has her hand up as well. Jennifer, would you like to ask your question?
Yes, can you hear me okay?
We can.
Yes, hello, Jennifer.
Hi, Mary. I sent you notice to this question. I'm not sure if you've already covered it. It's just whether you think the recent Supreme Court decision in Nuffield Health changes anything that you've said in your book. The Nuffield Health case was one where the Supreme Court held that a private gym that clearly excluded the poor and was only available to the rich was nonetheless a charity, part of a charitable entity.
Yes, thank you, Jennifer. In a word, no, it doesn't change anything. But I do appreciate that on paper, it rather looks as if this is very bad news for my entire thesis about public benefit, which is the whole subject of my first book. But actually, I'm satisfied it doesn't. The decision in Nuffield Health turns on the construction of one provision in rating relief legislation. I don't see any difficulty with the decision. I think as to whether that gym excluded people of modest means, the Supreme Court didn't have to rule on because its principal decision was fine anyway. So it didn't have to get into the debate between the first instance judge and the Court of Appeal. I do take issue with the greatest respect, of course, with the court when it says that the history of the meaning of public benefit is traced in detail in the Independent Schools Council case. I'm not sure that it is. And the extent to which the meaning of public benefit is defined and articulated in case law is actually very limited, as I set out in my first book in particular. And especially, I don't think it supports the interpretation on public benefit that has been made out by the Charity Commission, nor indeed the upper tribunal. And that first book is full of the arguments which I believe support that proposition. And the difficulties that I point out remain. The huge problems in law, logic, and practice over who comprises the poor or rich or people of modest means. The shift from charitable status to trustees' duties that the upper tribunal, for understandable reasons, was very keen to undertake. Very importantly, the relevance of any presumption of public benefit, which may or may not have existed before 2006. Also, extremely importantly, the question of whether we're talking about the poor being excluded expressly, impliedly, or as a result of fees. And most importantly, the existence of established case law prior to 2006, which goes completely against the interpretation that's now been placed on it by the upper tribunal. I am the first to accept that I'm wrong in an argument, and I'd be very happy to do so, but I would like to reserve my position until there has been an argument run in court that at least addresses the arguments which I and others have made. And that hasn't happened yet. It didn't happen fully in Independent Schools Council, and one can understand the council's position that actually some element of compromise, rather than running a purist legal approach, was probably in its interests. That argument was not run in the Supreme Court in Nuffield Health. There was no discussion there over whether Nuffield Health was a charity or not, whether it satisfied the public benefit requirement, because so much reliance was placed upon the fact that it was registered. But I still believe that if one day we have a case that asks whether a charity is, whether an institution is a charity, and the argument centres around the fees that are charged and the effect of those fees and so on, and if the argument is run in full that looks at the established case law, the 2006 Act and everything else, at the moment, I'm afraid I still stand by my arguments. And I would love to see those addressed in full in a court case, maybe one day, but it hasn't happened yet. So Nuffield, I'm fine. I'm fine with it.
I'm just wondering whether I could have a follow-up question. I wrestle almost on a daily basis with the line between charitable activities and commercial activities, and when commercial activities become an end in themselves as distinct from a means to an end. Do you have any magic wand there?
I wish I had magic wands. No, I don't have any magic wands. Yeah, I wrestle with it too, and I don't really address in the book. I appreciate that. There is a line between charities when they should conduct commercial activities. Of course, it's not outlawed by charity law. There are legal mechanisms for it, but even assuming compliance with all the tax laws and those legal frameworks and everything else, it does seem to me it's a question of balance, possibly, that if too much focus of the executives and the governing body is spent on commercial activity with a view to making money, which of course in itself is not a charitable purpose, does that tip over too much? Does it create mission drift, undermine charitable purpose? Does it affect the culture and the ethos and the values of the charities? All those sorts of questions. I think for universities, the line should be drawn exactly where we draw it for other charities as well. It is a debate I start in some sense in chapter 4, but I fully accept the question of commercial activities, funding of research, financing, spin-offs, intellectual property matters and so on. This is an area which I haven't covered in sufficient detail in this book at all. After 5 years and 550 pages, I honestly felt that was enough for anybody, but it is one of the areas, I think it's the prime area that I mentioned in chapter 11, needs further research. And I know there has been some interest, I'm really pleased, in Australia and England to maybe look at those sort of financial issues in universities, people with the expertise I do not have, but to look at them through a charity law lens. I think that would be a phenomenally useful exercise. Maybe they could come up with a magic wand. I'm sorry, Jennifer, I don't.
Well, Thank you, Mary. And perhaps I'm just conscious of the time. We've sort of got to our just over our allotted hour. So I think if people could join me in thanking Mary and also Matthew as well for joining us today and talking through Mary's wonderful book. Thank you, Mary.
Thank you very much. Thank you, everybody, for attending.
And we will circulate details of the recording after this, but also Mary asked us to include her contact email as well. So if people have got questions, comments, that's a way of getting in contact with Mary and continuing the conversation, because as Mary has already pointed out, there's a lot in this book, but also it really does prompt us to ask some of the big questions for which we don't have answers yet, and to work through those challenges. So I'm looking forward to the continuing discussions that this is going to prompt, especially around university governance, but broader than that for the charity sector. Thank you, Mary. And thank you, everyone.
I've just noticed I'm called Tim Singh on this picture. I'm so sorry. I should have changed that at the beginning. Obviously, my husband's been on Zoom. Sorry. Thank you, Ian, and thank you, Matthew, for the time you've dedicated to this and the support you've given me. And I'm really pleased to have had the opportunity today to do this. So thank you very much indeed.
Thank you.
Thank you.